Hi, everyone. We're going to give a few more seconds to let people join the webinar. So we'll get started here very soon. Well, I want to say good morning, good afternoon, everyone. Welcome to Seniors 201, Developments and Efforts to Protect Clients and Prevent Exploitation. My name is Josh Jones. I am one of the co-chairs of the firm's Senior and Vulnerable Investor Group. I work out of the Birmingham office, and happy to be here today. We're going to introduce ourselves so that you guys know who we are. But I came to the senior space with a background as a litigator, had seen some very difficult cases that clients were facing, recognized the regulatory and legislative interest that this topic has, recognized the interest that our clients and that the financial services industry has in protecting their clients. And so it's something that I really enjoy, that hits close to home for me with my parents, and so it's an important topic. It's one that I'm excited about the opportunity to be here today. We had a list as to the order that we were going to go in, which I have completely forgotten. So Taylor, I'll turn it over to you to introduce yourself.
Great. My name is Taylor Bandy. I am a third-year associate based out of Bressler's Fort Lauderdale, Florida office. I am a member of the Financial Institutions Group and also part of the Senior and Vulnerable Investors Group. So I'll get to tell you guys about it later on, but I help keep Bressler's senior map up to date with all of the new financial exploitation and APS statutes that are being passed. And Alex, I don't know if you want to go next.
Well, thank you, Taylor. My name's Alex Sabo, and I'm a principal in the firm's office in Miami, Florida. My focus on senior issues dates back to January 2004, when Bennett Falk, Keith Olin, and I opened Bressler's first office in Florida. At that time, I also became the firm's primary representative on the Florida Securities Dealers Association, and the FSDA began to focus more and more on seniors issues, primarily because we have a large seniors population here in Florida. I'll talk a little bit more about that when we get to my portion of the presentation, but I hope everyone enjoys the program. And if you stick around till the end, I'm going to give you a great summer salad recipe. That's from a guy whose parents owned a restaurant for 25 years. Ronak, over to you.
That's great. Thanks, Alex. So I'm Ronak Patel, principal in the Austin office. Before joining Bressler, I was at another law firm, but prior to that, most notably, I guess I was the state securities regulator for about 14 years. Served for about 5 of those years as deputy securities commissioner for the state of Texas. And it was during that time that we were starting to sort of see a lot of ramping up around, statutes and rulemaking and efforts to enhance both education, controls, reporting requirements, and safeguards into policy. So, as Josh shared, I mean, this is something that, goes back a bit kind of from a personal element, as having been involved in some of the things very early on. And happy to kind of be here today to share updates.
Great. Well, thanks, everyone. So we've styled this Seniors 201, and I'm sure that a lot of the attendees have attended our kind of introduction, where we walk through the basic signs of exploitation, red flags relating to diminished capacity. We walk through Senior Safe Act, various report and hold laws, and things along those lines. And we're going to assume today that you guys have kind of a general familiarity with this topic. If not, we're certainly happy to always talk seniors. We have a lot of clients on the phone today. If any clients out there want the Seniors 101 presentation, whether it's to legal compliance, to the sales force, we're always happy to do some training, to do some discussion, and really appreciate those opportunities. We've the presenters on this panel and elsewhere in the firm, we've discussed these topics for the SIFMA CNL. We've discussed it with a number of our clients, with ABA events, with the NSCP. And so we regularly speak and write on these issues, and are happy to do so moving forward. Today, we're going to talk about 3 specific areas that are going to cover some basics, but also maybe some more nuanced discussions and topics than we might in our typical presentation. So Ronak is going to take the lead on discussing some of the regulatory issues that we're seeing. Alex, as he mentioned, is in Miami, and so he's going to take the lead on what's happening down in Florida. Obviously specific to Florida, but a lot of that will be takeaways that are applicable in a number of states. And then Taylor and I are going to talk about the recent trends in the exploitation laws that we're seeing kind of across the country. I like to start these, particularly when we do this with a sales force, but even for you guys, just take a minute and think about a senior in your life that you care about. It could be a parent, an aunt, spouse. It could be grandparent, family friend, the neighbor that always feeds the cat when you're out of town. Think about that. Get a picture in your mind of that person, and then realize that there are people who are actively trying to take advantage of that person, who are actively trying to steal their hard-earned life savings, that there are people that, if given the opportunity, would take every dime that senior has and ever will have. And realize that firms, that brokerage firms are, in a lot of cases, and in some ways, the front line, the first line of defense, and on the front lines in combating these efforts and working to protect seniors. It's a very important job that you guys are doing. It's something that I know that you take very seriously. We are proud to partner with the industry in this effort. And I like to start the conversation that way, because to me, at least, it brings it home that these are real people who are in harm's way. And the sad thing about it is, one of the sad things about it is, it's oftentimes people that are closest to the seniors that are doing the harm, that are trying to take advantage of them, whether it's a caregiver, whether it's a family member. There are people that are trying to take advantage of your clients and your loved ones. We do have CLE today, so we'll be giving out 2 passcodes, one towards the middle, one towards the end. We have the Q&A function open in the webinar. So if you have questions, please use that function. We'll try to address them during the presentation. If we're not able to do so, we'll follow up directly with you. And as I said, always happy to talk. The first topic that we're going to discuss today is the regulatory focus. What regulators are looking at. This is something that is obviously incredibly high priority for a number of regulators across the country, both state and federal. And Ronak, why don't you get us started?
Sure. Thanks, Josh. And kind of before I get into regulators and the regulatory focus areas, I mean, that sort of image that you cast out there, took me back to something from my regulatory days very, very poignantly just in that moment. I had a victim of a Ponzi scheme, 70 years old, testifying at sentencing, federal sentencing, and he's talking about how he'd saved money his whole life, was saving up for his daughter's wedding, and was just destroyed to the point where he couldn't even get words out of his mouth while he's testifying, talking about how he has to go back to work, how his life's been completely ruined. And I share that, I guess, in part because those are stories that the regulators have playing in their minds over and over and over again, right? Versions of those. And so, that's one of the many reasons why they take this issue so seriously. And quite candidly, in my experience, in our experience, what we've seen with regulators in the space is they see this as an area of cooperation of industry participants across the board, and regulators and other government and agencies, having an opportunity to work together, having strongly aligned interests in this regard. And that's an important thing for you to remember if you ever, in sort of how you're going about developing and thinking through your systems and processes, but also if you find yourself in a situation where a client has been victimized and has been exploited, do know that, yes, you're going into a regulator, which can be intimidating, and can present its own set of risk, obviously. But at the same time, if you've done the things that they're expecting of you to do as a firm, as an institution, as individuals, there's going to be, in my experience, a lot of understanding there and a lot of room for positive advocacy and aligning. So don't ignore that real sort of viewpoint that exists out there in this space, because it's not always the case, certainly, but in this particular case, I see there's plenty of opportunity to talk about how you're aligned with the regulators. That big picture viewpoint's interesting to me.
Yeah, Ronak, that's my experience as well. And it's actually one of the things I think that kind of drew me to the space. As a litigator, everything's a fight. We argue about everything all day, every day. And in this space, it's, I'm able to take my litigator hat off and talk to firms and talk to regulators about, what we're doing and what we've, no system's perfect. And, there are criminal masterminds who are trying to steal your client's money, and so there's obviously going to be issues. But I do that sense of alignment and of all being working towards the same goal is I think it's real.
Yeah, it's something to keep in mind. Again, sort of on the advocacy side, should you find yourself in that position as well. And so really, how do you show your alignment? Right? How do you show that you're invested in this? And that's something we're going to spend a little bit of time just talking about from an overview perspective. I think Alex, Brandy, and Josh are going to really kind of get into some specific examples, but the overarching elements around what's the priority here are important to think about. And we've got kind of, it is prevent exploitation, but of course it's going to occur. And how quickly your firm is prepared to identify and address it when it occurs is critical. It's critical to your compliance obligation, critical to your ability to, find civil and regulatory liability, either shields or at least mitigating factors. And so, at this point, now we're fast forward. I mentioned that when I was a regulator, that's when we were starting to see a lot of heat in building up around this space. At this point, I think expectations are pretty high of the regulated firms out there. We see firms an expectation that firms will have developed protocols, training, controls, and systems to both identify and report these in a timely and effective manner, right? So one of the things that often comes up is, well, what is exploitation? Like, how do I know that this is something that needs to be followed up on or needs to be reported? And we have a 4-year-old who exploits his grandparents every day. And thankfully it's only for treats and toys so far, but sometimes I'm wondering if we need to report him for exploitation. Kidding aside, it really is difficult at times to identify what is exploitation, and more precisely financial exploitation. the definitions are out there. For example, in Texas, you have to go to the finance code to find what exploitation is under the state securities laws. Well, in Texas, for example, and then there's similar definitions across the country, it's forcing or compelling or exerting undue influence. Well, these aren't things, some of these are going to be black and white, but what is undue influence? How do you measure that? And you're seeing indications of behavior that's inconsistent with the person's recent past behavior. But is that because there's something else going on in their life that you don't fully understand? Or is that because somebody's subjecting them to an influence? And is that influence so of the nature that it's undue? What does all this mean, right? These are hard things to kind of dive through. So one of the things that's important for firms to utilize here is training. Get your staff comfortable with understanding where the lines are and build protections internally for sending that message up, because you don't want, these are often situations where there's embarrassment or risk associated with it, and you don't want your staff or personnel to be hesitant. If they see indicia of it, they don't necessarily need to be 100% sure, and we'll talk about that later. There's protections around when you report this and flag it, but you should train your staff to be mindful of the types of elements that really are indicative of exploitation, of diminished capacity. And there's plenty of training material out there. You should get that training in front of relevant personnel. That includes, go ahead, Josh. I don't know if you have a question.
Sorry, yeah, I was just going to make a pitch for the joint NASA, FINRA, I think maybe the SEC training. It's up on the FINRA website. I'm pretty sure it's qualifies for training under the Senior Safe Act. It's a 1 hour webinar, along these lines, and definitely, would recommend it to our viewers. Also, we're obviously happy to conduct trainings. We do it on a regular basis, and happy to work through and develop a training really tailored around the firm's processes, the firm's policies and procedures, their escalation, triggers and things along those lines. So just wanted to touch on the training aspect a little bit.
Yeah, and NASA's got a great website that's got all sorts of resources out there, in particular senior issues. So, and that's NASAA, not NASA, like I usually try to do, even though I should know better. So one of the things that's important with the reporting laws is there's a good faith and reasonable care kind of component standard built into all this, and you should be mindful of that again. And that's important because we don't want our personnel to be thinking that getting this exactly perfect, because sometimes perfect assessments in this case can be the enemy of right, and it's going to be too slow of a process. You're going to get, you're going to not be able to get the messaging and reporting done as quickly as possible. But do train them to not just take information from third parties or other interested parties, just at their word. Train them to understand, where's this information coming from? Is there documentary support? Train them to document the steps they're taking, the discussions they're having, because ultimately that's going to support your ability to feel confident in reporting potential exploitation or indicia of exploitation forward. So those are some things that we wanted to kind of just touch on. Josh, I know you're kind of sliding us forward here.
Well, I know we've got a lot to cover. And I know you wanted to touch on the enhanced penalty issue.
No, all good. Let's keep marching, and there's plenty of things we can come back and talk about.
Yeah, and one of those is the diminished capacity among financial advisors. I think we're planning a webinar on that in the fall. So just kind of wanted to make a pitch for that, because it's certainly an issue that is of interest to our clients, the industry, but also to regulators as well. And then, Ronak, you'd listed some of the focus areas that you're seeing that regulators are paying attention to.
Yeah, and this is more just kind of, a listing for folks to be mindful of during exams, investigations, and during instances where unfortunately we have seniors who have been victimized either by third parties or in unfortunate cases by financial advisors. These are amongst the kinds of things that we look to see, that we see sort of being focused on by regulators, I should say. And there's a mention in the previous slide about systemic controls, and that should be probably on this slide, frankly, because a lot of the cases I've been working on recently where it involves seniors being impacted, there's questions around what are your fraud controls, external fraud, internal fraud controls? How are you monitoring communication reports? What types of exception reports do you have in place? What kinds of financial transfer monitoring tools are in place? And how do those get escalated? Those are the kinds of issues and questions that we see coming up often amongst this list as well.
Yeah. And the one I wanted to mention that you bolded there is the trusted contact. Look, you're not required to get trusted contacts, obviously, but you are required to ask. And the various firms, I think regulators are starting to analyze different hit rates, I guess we could call it. Different. Some firms are a lot more successful in securing a trusted contact than others. I tell people it's the easiest and certainly the best thing you can do for investor protection. My general impression is that when it's important to management, when it's important to the bosses, it's going to be important to the sales force, and that's going to make its way down. And when it's important, the level of return is going to be higher.
And one more thing, and I'll shut up, promise. So FINRA put out on that point on trusted contact forms, FINRA put out a good notice at the end of last year, 2231, I think. Let me check. I had to, 2231. That's worth checking out because what it does talk about is, sort of the types of ways that you can train and enhance the utilization of these at your firm.
Mm-hmm. And then I think this slide, the last one in your section, Ronak, just understanding the expectations, I think it's critical. And like you said, the first question they're going to ask is, okay, what's your, what systems do you have in place? And the answer is, hopefully a strong one. What kind of trainings have you done? Hopefully, it's been a focus. It's been something you've been involved in.
Yeah.
And so I'll give out the first CLE code, but why don't we shift? So it's going to be two words. The first is summer. So summer is the first CLE code. And with that, we'll shift down south to sunny Florida. Alex, take us away. Hey, Alex, you're on mute. Alex, you're on mute. There you go.
I understand. I was just doing that to try to stir you up a little bit, Josh. And it is sunny here today. So the starting point, of course, is Section 517.34 of the Florida statutes. Became effective a little more than 5 years ago. It's called Protection of Specified Adults. It took almost 5 years from the date on which the first draft was written until it became the law in Florida. And the journey from that first draft to passage was certainly one that was fun to be part of, like I was. And I can tell you that it took almost 5 years because I wrote the first draft on July the 5th, 2015. This statute was pushed by the Florida Securities Dealers Association, joined by, of course, other industry groups and trade groups who are interested in these issues. And it was really something to be involved in the process. We had to meet with the legislators, had to meet with various state agencies, try to generate support for the statute. But eventually it came together, and after 5 long years, and at times it didn't seem like the statute would pass, it did pass and become the law of Florida. It's part of the Florida Blue Sky laws. It's a hold and report statute, and it defines to whom it applies. It's not just persons 65 and older. It also applies to individuals who are defined as vulnerable adults under Florida law. So I recommend you to go read the statute. Okay, so let's talk about what's a hold. Probably pretty much like everybody already knows what a hold is. A hold is nothing happens, right? It applies to disbursements from and transactions in an account. That was one of the issues that we really debated when we were drafting the statute, was we should include transactions in, because those oftentimes can have significant tax consequences. So we included transactions and disbursements. You get to hold for 15 days. You can extend it for 10 business days if your internal investigation, and you have to start an internal investigation if you place a hold. Your internal investigation continues to suggest that financial exploitation is out there. In other words, I guess like Sherlock Holmes would say, the game is still afoot. So if you think the game is still afoot, you can extend the hold 10 business days, and a court of competent jurisdiction can shorten the hold and extend the hold. And that's going to become a little more important when I get to another statute. So what's the report? The hold is 15 business days and an additional 10. The report, we have to do a couple of different reports, and they have to all be in writing. You have to give written notice to the Office of Financial Regulation. You have to provide specific information to them, and you have to do it on a form they prescribe. It has to be done within 3 business days of placing the hold. Now, it's very important to only provide the information that's specified by the form. See, Florida has a Government in the Sunshine Act, and a lot of information that goes to state agencies is available for public viewing. So that's why you essentially, what you would give would be the gender, the age, and the zip code of the specified adult for whose account the hold is placed. Now, the person placing the hold has to give their name, their title, the firm they're with, and their address, but you don't give that type of information for the specified adult for whom the hold is placed. And you can always terminate the hold after you do your investigation and you find that, well, the hold was not really necessary. You can simply terminate the hold. You don't need to extend it. Being part of the Florida Securities Dealers Association, when we've had meetings to discuss this, uniformly the membership says that they've received nothing but kudos from individuals whose accounts on which they've placed a hold, because those persons are so happy that somebody's looking out for them. So please keep that in mind. This is a very, very good thing. You've also got to give written notice to persons authorized to transact business on the account, and that could include the trusted contact, again, within 3 business days. You don't give any notice to the suspected financial exploiter. In other words, you don't tell the evildoer we're on to you and we're coming after you, okay? You just give it to people who are authorized to do business, including the person who owns the account plus the trusted contact.
And in a case where you have a belief or a suspicion that the exploiter is the trusted contact, the fox in charge of the hen house, the no notice provision would govern, right? You don't give notice to the exploiter under any circumstance, whether they're assigned to the account or not.
Absolutely, positively. Even if they're just a trusted contact, they can't transact business in the account, and you think they're the person that's behind the suspected exploitation, you don't tell them, you don't alert them. You alert the OFR and other people involved in the account. And I get a few minutes down the line, I'm going to tell you who else you have to alert to, or who I think you should alert. So you've got immunity. All right, you get immunity under the statutes. It's civil and regulatory. What do you have to do? The things that I've got there. You have to train employees, adopt policies and procedures, give the required notices, launch an immediate investigation. I repeat, launch an immediate investigation. If OFR wants records, you give it to them. And you got to have a reasonable belief of exploitation. If you do all of these things, you get the immunity, and that doesn't diminish or supersede the immunity that you can get under Chapter 415, which deals with adult protective services. I'm going to talk about that in a couple of minutes. So how do we summarize all of this? just think of DICE: documentation, investigation, communication, and education. Train the people who deal with clients. Communicate internally within the firm. Communicate with the trusted contact and the persons on the account. Communicate with the Office of Financial Regulation. Do an investigation. Documentation. Give the written notice that you're supposed to give under the statute to OFR and the people on the account, but also for those of us who try cases, please keep written record of everything you do, because that's great evidence to have if a lawsuit comes up down the line. So that documentation is very, very important. You are creating evidence that may eventually win the case for you. Now,
you're creating a paper trail that allows us to prove that the firm acted reasonably and in the client's best interest. And that's important whether in litigation or in dealing with a regulatory inquiry.
Exactly. Now, I want to talk a little bit about some recent comments that the Florida Office of Financial Regulation gave at another seminar that Taylor attended. 25 firms are filing reports. If there's a hold been placed on a disbursement, there was also a report made to Florida Adult Protective Services, which the Office of Financial Regulation likes to see. And who are committing these crimes? Who are taking advantage? It's scammers, caretakers, friends, family members. Not a single case has involved a registered representative, at least as far as the OFR has seen to date. Echoing something that was part of Ronak's presentation, the OFR is seeing diminished capacity issues among registered reps. But on each occasion, the OFR has been told there's no business continuity plan. So go take a look at FINRA Rule 4370. Try to get those business continuity plans in place and emergency contact information, because you may face issues involving diminished capacity among registered representatives. And also make sure you talk to your HR department, because there are employment law issues that can come into play there.
And Ronak, I know that the business continuity plan, that's been something that has been raised as an issue by a number of regulators. Obviously, FINRA would be the one that jumps to mind.
Yeah, and the one thing I'd say is, if your firm may have sort of business solutions in place. I mean, I'm increasingly seeing firms develop, business solutions that foster and make it easier for representatives to start thinking about their plan out. Like, I'm not just giving my book away, which is going to be a common concern, and that's going to be one of the things that can hold this back from progress. If your firm may have solutions already developed, if not, that's something that we're seeing across the industry that's supportive of the regulatory concern there.
It's definitely a general issue, but it is something that I think is right to raise in the senior space, and it's one that isn't necessarily it jumps to the forefront when you think about senior vulnerable and client issues, but it's certainly something that bears consideration. And Alex, you mentioned the APS statutes, and Taylor's going to talk a little bit later about kind of interplay between report and hold and APS statutes, but all states have them. Florida's, I think you said, is set forth in chapter, what is it, 415 there? Yeah, so
that's exactly right. And it's a statute that's been around a long time, these provisions, this chapter, and it's got mandatory reporting. And the mandatory reporting just doesn't apply to the people specifically mentioned in the statute, it applies to everybody. It's one of those statutes that says any person, including but not limited to, then it has a laundry list, which includes securities dealers and investment advisors, must. So it's everybody. It's everybody who thinks they believe exploitation is going on. And how do you report? Get in touch with the Central Abuse Hotline. They got an 800 number. You call them up, you give them the information. And if you're acting in good faith, you get immunity from civil and criminal liability. And if you're acting in good faith, not only do you get immunity from civil and criminal liability, but if you're an employee and there's adverse employment action taken against you, you have a cause of action for whatever happened to you, including punitive damages. And remember that under 415, records and reports are confidential. Now, oftentimes that can lead to a little bit of an issue, depending upon the investigator with whom you're dealing. Some investigators for APS are more forthcoming than others when it comes to an ongoing dialogue regarding issues. One of the things that the Florida Securities Dealers Association is going to try to get passed in the next year is an exception so that there can be an ongoing dialogue. If you make a report under 517.34, you can have an ongoing dialogue with the APS investigator and APS regarding these particular issues. It's just a question of finding sponsors because I've already drafted that amendment to the statute. It's all ready to go.
And
Yeah,
go ahead, Ron.
Oh, I was just going to throw in a quick point on that. You know, as somebody who spends a lot of time talking to investigators at different agencies, you know, one of the things that's helpful to think about for you as a firm is build relationships with these people. Like especially if you have a department or personnel that are assigned to these issues, have them develop relationships with various stakeholders on the adult protective services side, on the securities regulator side, because what that's going to do is facilitate conversation, make those conversations easier, enhance your ability to talk, perhaps within the bounds of what they can say, but still providing enough information. So I think having those kinds of that comfort is an important piece of what Alex, you just touched on. So just want to throw that in there.
I'd just like to add one more thing if I could. If you're going to place a hold on an account for a specified adult, make the report to Adult Protective Services too. Because like Taylor heard at the seminar she went to, the Office of Financial Regulation wants to know you've made that report. And it is the primary agency for investigating these issues in the state of Florida. So make the report. You also get that civil and criminal immunity. All right, so we got a couple of other statutes to talk about very quickly before we get to Taylor's presentation. Florida's got a statute 825.1035. It's found within part of Florida's criminal code. It's an injunction for protection against exploitation of a vulnerable adult. As a result of a recent amendment, it's also going to now apply to persons who are 65 years of age and older beginning on October 1st, 2023. I only mentioned it because it talks about temporary and permanent injunctions, including ex parte injunctions against various parties, including financial institutions. So an account at a financial institution can be enjoined if there's some belief that what's going to happen in the account is the product of financial exploitation. However, the statute isn't too clear on whether that applies to securities dealers and investment advisors. But remember, under section 517.34, a quote court of competent jurisdiction can extend to any hold that's been placed by the broker dealer. So in a situation where this type of lawsuit is going on and you're coming up on the expiration of the hold and everybody thinks exploitation is still afoot, certainly a court could extend that hold because it's directly permitted under the statute. So that's 825.1035. Just one more. All right, that's going to be 817.5695. This one becomes effective on October 1st, 2023. This is a criminal statute. It contains penalties up to life imprisonment for persons who do certain things. And I mentioned it because, as I said, you can also get an injunction under the prior section that I discussed, but also because this statute covers all kinds of horrendous things. It covers bribes, kickbacks, threats. It covers contracts. It covers wills, trusts. So if a person, say, for example, is threatened, I think they call it coerced debt. You're threatened to take out a loan for somebody and guarantee that loan. It's covered by this particular statute. If you're a person who is, you find out someone is being asked to, they want to put a new roof on their house, which might be legitimate, but the roofer is saying, well, you don't want to go out of pocket with the money. You want to get a loan through a company I can introduce you to. Well, guess what? What we're seeing more and more is the person signs up for the loan, the roofer disappears, and the loan with the company has been discounted and sold to another person that now wants all their money because they gave value to the company that got the loan initially. That's what's going on, and that's what our seniors are seeing. So this is a new statute. It's a criminal statute, but it does spill over to the civil context, and it's intended to reach some very specific things that are going on with our senior population. Should I give them the salad recipe now or wait till the end, Josh?
Let's wait till the end. I don't want people to drop off after let's save it for the end. A lot going on in Florida. Obviously, a lot of seniors in Florida, a lot of financial services firms that have large presences there, a lot of client base. So this is something that we're obviously watching very closely, very intimately involved with. Alex would be happy to talk to most any of you about what's going on there. Some of this is, like Alex said, still to be put into effect. But obviously, Florida, it's not limited to Florida. There's a lot going on across the country, and it's something that we're following closely. These laws, these developments, it's a lot. It's a lot to keep track of. Taylor, you're very involved in the firm's efforts to stay up to date on what's going on across the country, and happy to have you walk us through some of the things that you're seeing as part of your work.
Thank you. So do you mind going to the next slide, Josh? So as Josh said, I, along with Kirsten Nowak, we go over all of the state's financial exploitation and APS laws and any bills that could impact any laws that have already been enacted. Every monthly, we do a deep analysis, but then sometimes every day we're tracking different bills. So just as a brief overview, because again, we're assuming that you guys have some knowledge of state financial exploitation statutes. These are kind of the key parts that we see in these statutes. It's either based off of which state you're in, there is required or permissive reporting to the state APS agencies and or the Securities Commissioner, and sometimes even other agencies. There are permissive temporary holds of suspicious disbursements and transactions that usually, almost always, I think there's one state that's an exception where it triggers mandatory written notification then to the trusted contacts or individuals reasonably associated with that account. In general, if you don't place a hold, normally the third-party disclosures are permissive. And then some states, their financial exploitation laws have required training provisions. Some are much more in depth than others. And I think another good thing to point out is that the holds are only allowed when there's either a senior or vulnerable investor. Usually vulnerable is 18 and up, with some part of either physical or mental impairments to where that they can't do day-to-day functions on their own, and there has to be exploitation suspected. You can't just say this person has diminished capacity, they may not understand what they're doing. That's not enough to place a disbursement hold. So a new trend that we are starting to see, and Alex spoke about earlier, is the right to investigation status. So as Alex mentioned, the FSDA is advocating for Florida's financial exploitation law to be revised to allow firms to just even get an update on the OFR's investigation, to know whether the investigation has been concluded. Right now, firms are really left in the dark. So we're starting to see a shift towards allowing firms to at least know the final status of these investigations. Georgia's Senate Bill 84 was enacted in May of this year, and that created a financial exploitation law in Georgia that just went into effect at the beginning of this month. And it allows firms to contact Georgia's Securities Commissioner and, find out the final disposition of any of the investigations. And so this is something that we think is great, and we're hoping more states continue to allow firms this insight.
And I'll tell you, this is one complaint that we hear on a regular basis, and a lot of it is state specific, I think, or even Ronak, to your point, investigator specific in some ways. But firms file these reports, raise these red flags, raise your hand, point to the potential wrongdoing, and then nothing. They have no clue as to whether it has even been investigated, and if so, what the results are, what the status is. So this is something that we're closely watching. It's something that the industry is very interested in, and rightfully so. Ronak, I think to your point earlier about kind of being aligned and having regulatory and the firms aligned to in efforts to protect seniors. This is just another example of that, and another step in that direction.
And then another trend that we are seeing is revisions to the third-party disclosures. So the financial exploitation laws that were enacted, there's been a big shift where there's been a lot more enacted recently. There were some enacted a couple years ago. Originally, the third-party disclosures were to quote unquote previously designated third parties. So that is, like we all know, the trusted contact person, someone that prior to any financial exploitation, the individual told the firm could be contacted. We're starting to see this shift where financial exploitation laws are allowing disclosures to a broader group of people who they call reasonably associated with the accounts. This is going to vary among states. Some states will define this term. Other states, you kind of have to use your judgment. It's not as clear cut, but examples of these types of individuals would be immediate family members, trustees, someone acting under a valid power of attorney for the adult. And then sometimes the customer agreement will say that certain individuals can be contacted, or some states have specific laws that also cover that.
Michael had asked a question in the Q&A about reasonably associated, and it depends on the statute as to what that means. Sometimes it is defined, other times it's not. And he raises an issue about reconciling this particular issue with the senior's right to privacy. And I'll say that this kind of goes to an issue that I'm really interested in. There's a balancing act. You have, on one hand, you have investor autonomy. Just because someone turns 65 doesn't mean they lose the right to make decisions about their investments, about their money, things along those lines. It doesn't mean that they lose the right to make bad decisions. They don't lose the right to privacy. They don't lose the right to keep their financial information to themselves. But on the other hand, you have preventing exploitation and protecting the most vulnerable population that we have from financial exploitation. And how do you balance those two things? What we're seeing is these days the balance seems to have shifted a little bit in the direction of protection, in the direction of disclosure. As you're doing that, you're almost by definition moving away from the investor autonomy issue. I will say that even Graham Leach Bliley has a fraud exception, and so we have generally counseled firms that want to make these types of disclosures when it's not provided for in statute, that they're not barred from doing so by Graham Leach Bliley. Now, there may be other state statutes that would be, and it's obviously a fact specific type of analysis, but there are these other type issues that are out there. And so this is one that I think is very interesting. Getting the trusted contact, getting that information up front is obviously helpful. But when you don't have it, this provides a bit of a backdoor. One other thing that we've seen along these lines is we've seen firms that have addressed this issue in their customer agreement. That they've revised their agreements or drafted their agreements in a way that allows them to contact people reasonably associated with the account under certain circumstances or when they have certain concerns. And Dana had asked a question in the Q&A that kind of touches on this. Registered investment advisors aren't, there is no trusted contact rule. The FINRA rule obviously doesn't apply to IAs. And so, Dana, in response to your question, that's one way that we've seen registered investment advisors address it is through their customer agreement. Ronak, any thoughts on this issue or investment advisors or
Yeah, no, I mean, if you look at the FINRA rule, it's in the customer account information from a rulemaking perspective, right? And so there's not a mandate yet at the RIA level, but as best practices, we're seeing advisors across the country, seek to collect this information. Now, they don't have the same sorts of pressures as to what degree they need to push for that, et cetera. But from a marketplace perspective, RIAs should definitely be mindful that there's an increasing use of this even without the mandate.
I was just going to add that the Florida statute pertains to both securities firms and investment advisors. When we drafted the statute, we included investment advisors in it, and it mentions trusted contacts and defined trusted contacts. So if you're an investment advisor, get a trusted contact because you're covered in Florida.
Interesting. Yeah. And I'll say, Taylor, most of the exploitation statutes that apply to broker dealers would also apply to investment advisors and the report and hold. In fact, I'm not thinking of one that wouldn't.
Right.
Well, we talked about good news, maybe some bad, I won't say bad news, but a burden on firms in Georgia as well.
Yes. So we talked about exciting developments, and then we have also seen some concerning recent trends. Georgia's new financial exploitation law requires firms to continue that internal investigation, complete it within 7 business days of whenever the disbursement or transaction at issue was requested. They have to report back those findings to the Georgia Securities Commissioner. 7 business days is not that long, especially for some of our clients who are large national firms who are just inundated by these different financial exploitation cases that they have to research. So this is just adding another burden on these firms to have to then finish their internal investigation, go back and report. And Georgia's not the only state that we have seen this. I know Montana requires 7 days as well reporting, and they have to report not only to the Securities Commissioner, but also APS. And Vermont also requires that, again, within 7 days. So this is just an added burden when, some firms are already under a bit of a time crunch to just comply with the normal reports.
Just the report, right?
Yeah, just to get the filed report out of suspected financial exploitation. So now to have to report their completed investigation findings, that's a large burden on some of these firms.
Absolutely.
And then another trend, we're going to go back, we're going to end on a good note. So the original financial exploitation laws, the states that had enacted them a while ago, they were just the holds. If the state allowed a hold, it only applied to disbursements. we're starting to see a trend where states pretty much always are just throwing in disbursement and transaction holds, which I think this is great because at the end of the day, you know, they're similar in the sense if financial exploitation is being committed, that is going to cause harm to these senior or vulnerable adults. And as Alex said, sometimes with these transactions, there can be tax consequences. So I think it just makes a lot of sense to allow, if you're going to allow holds, to allow them for both disbursement and transaction holds.
Yeah, this is an undeniable trend. The federal rule that it was amended, I think, within 2 years or right at 2 years to apply to transactions in addition to disbursements, and the laws that we're seeing passed across the country are applying to both, and a lot of states are going back that initially only applied to disbursements are going back and adding in transactions as well.
Right.
Taylor, go ahead.
And just to add what Josh was saying, it's not an added burden on the firm. If you place either disbursement or transaction hold within that state, all of the reporting notification requirements are the same.
Yeah.
So it varies among states, but if once you're within a state, whether it's a hold or transaction, it's the same for reporting.
We have just a few minutes, and Taylor, I do want you to talk about the map. Before we do that, so the code, the second code word is salad. Salad. So summer salad is the CLE code. And so Taylor, we pulled it up. This is available. We put in $250,000 of attorney time into building this map out, and then we gave it away. We gave it away to the industry. We gave it away to our competitors. A lot of you on the call are regular users of the map. Taylor and her colleague Kirsten, work hard on the map to make sure that it's up to date. If you ever see anything that's not right, or that you have a question about, or a link's not working, or whatever, please email me. Please email Taylor. Let us know, and we'll get to the bottom of it. Taylor, just quickly, what is the map, and how do people use it?
Yeah, so you can go to the link at the bottom, which is on Bressler's website. And as Josh mentioned, it is free to use for anyone. You just enter your name, email address. I promise we will not send you emails regularly if you put your email address in. But basically the map is highlighted. It looks like this on the screen. You can click on any state and it'll tell you whether they have a financial exploitation statute. It'll show the APS statute, and it'll show the pertinent information such as how that state defines a vulnerable adult, what age is considered a senior. Some states it's age 60 and up, some states it's 65 plus. It'll tell you who the report should be made to. We usually include links. So some states you can report via a phone number. Other states, they have electronic forms that you fill out on a website. It'll discuss whether that state has a hold provision in their financial exploitation law and any of the requirements on that. So it's a really great resource, as Josh mentioned. And then we also have some clients that we create a non-live version of the map, more in a PDF version with additional information that they want. And so if you find you need additional information that is missing from the map for states' financial exploitation laws or APS laws, you can reach out to Josh or I, and we can work with you on that.
Yeah, we're happy to customize it, provide monthly updates. We do that for a number of clients. It's a great resource, allows us to build relationships with the teams, and we're happy to talk about that with any of you guys. We have 1 minute left. Alex, people are going to have to email you for the summer salad recipe. I'm sorry, we're not going to get there, because I do want to mention the California statute that has not been passed. So I guess it's not a statute. The law has not been passed. My understanding is that it's not likely to pass this year. It's California Senate Bill 278. Frankly, we're going to have to save it for a later day, but it is, effectively in some ways weaponizing the report process to generate potential liability to firms. It's very concerning from my perspective. I think from the industry perspective, I'm pleased to learn that it's very unlikely to be passed this year. But I do think it's something that we're going to have to keep our eyes open for and watch out for. Just want to thank our panelists. Great program, very informative. I hope you guys enjoyed it. Please feel free to shoot any of us an email and let us know there were some questions that we weren't able to get to that we'll try to respond to at a later date. So thanks, everyone.